Civil Liberties Project. Libel is written defamation. It is false information intended to harm someone's reputation. Examples of libel include books, magazines, or newspapers that have false statements. A realistic scenario that involves libel is if a magazine claims that a local business is stealing money from its workers. Slander is similar to libel, but it's oral defamation. It's false information spoken to ruin someone's reputation. Slander can come in the form of a podcast, video, or other live news report. An example of slander is this statement: Johnny Smith works for a corrupt company that uses unfair labor practices. This is not factual and intends to harm Smith's reputation. Libel and slander are both very similar, but they have slight variations. Even though they are both serious offenses, libel is often seen as easier to prove because there is a written record. It's common for celebrities to sue for libel, even if the process itself can be difficult. This is because the public figure, the plaintiff, has to prove that actual malice was committed by the defendant. This means that it must be proof that the defendant knew the statement about the public figure was false or was doubtful of the statement being true. A famous example of a defamation case is the Johnny Depp v. Amber Heard trial. In 2019, Depp sued Heard for defamation for portraying him as an abusive person in a Washington Post op-ed. He asked for $50 million in damages, and eventually in 2022, a jury ruled in his favor. While this case was recently covered by the news, one libel case made its way all the way to the Supreme Court of the U.S. in the 1960s.
In 1960, the New York Times published an advertisement created by civil rights supporters, like Martin Luther King Jr. supporters, that opposed the Montgomery, Alabama police. The commissioner of police in Montgomery at the time, L.B. Sullivan, sued the company for defamation for some inaccuracies in the ad. The judge in the local county court ruled that it was defamatory per se, but the New York Times appealed the ruling, going all the way to the Supreme Court of the United States. This is the New York Times v. Sullivan case.
And by the time the New York Times versus Sullivan reached the Supreme Court in January 1964, public officials across the South were suing and suing and suing newspapers, television, and radio stations for libel over honest mistakes and the slightest inaccuracies to make them pay, covering the civil rights movement.
In a unanimous decision, the justices ruled in favor of the New York Times. They ruled that when a libel case revolves around a public figure, the plaintiff has to prove that the statement was false and that either there was knowledge of the act or a disregard for the false nature of the statement. Justice Brennan authored these terms, and this is where the term actual malice comes from. Thus, this policy protects the freedom of speech from the First Amendment and stops public officials from winning cases of defamation when it is not appropriate. The future of libel and slander is unknown, especially in recent times with the onset of a global pandemic. In fact, a common question that is surfacing is who decided what is truth and what is misinformation? Recently, the definition of actual malice has come into question by Supreme Court Justice Clarence Thomas, who appears to align with Donald Trump. He believes that libel laws put rich citizens at a disadvantage. Regardless of these questions surrounding libel and defamation law, it is imperative that everyone is educated on the topic and understands how malice contributes to it.